A very good afternoon to all the participants. I hope the voice is very clear right now. So we'll be resuming very fast. In 10 minutes we'll be starting. So I good afternoon. Good afternoon, Miss Rajanam Patil, Yamini Shri, Dinesh Borase sir, Mohammad Shahid. Good afternoon. Doctor. Good afternoon, Vijay Lakshmi. Good afternoon, Shashikant sir. Good afternoon, Dr. Swami. Good afternoon, Mohan. Good afternoon, Vijay Lakshmi ma'am. Good afternoon, Sharmila ma'am. Good afternoon, Vijay Lakshmi ma'am. Good afternoon, Aruna. Good afternoon, Sebastian. Good afternoon, Sumati. Good afternoon, Raju. Good afternoon, Shan Mugam. Good afternoon, Alka. Good afternoon, Neha. Good afternoon, Yogendra. Good afternoon, Altaf Hussain. Good afternoon, Kumaran. Good afternoon, Rahul Singh. You can make a small introduction about yourself in the chat bot, which college you work for. It will be a healthy interaction among the faculties. It will help the other faculties to connect with you. We can utilize this coming 3 minutes in this. You can introduce yourself to the other people in this chat room. Good afternoon, Pooja. Good afternoon, Qasim. Good afternoon, Avinash. Good afternoon, Manjula. Good afternoon, Sharmila. Good afternoon, Amir Suhail. Good afternoon, Geeta. Good afternoon, Megha Raja. Good afternoon, Afroza Khan. We'll start in 2 minutes. Good afternoon, Avinash. Good afternoon, Akshay Kumar. Good afternoon, Archana. Good afternoon, Safa. Good afternoon, Avinash. Good afternoon, Harshita. Good afternoon, Aruna. Good afternoon, Thangaraj. Good afternoon, Yogendra. Rahul Singh. Good afternoon, Shagufta. Good afternoon, Samir Sheikh. Good afternoon, Bande Nawaz. Good afternoon, Jay. Good afternoon, Shivaji. Good afternoon, Shobha. Good afternoon, Uma. Good afternoon, Venkatesh. So I think it's 3. It's the right time to start with the session as per the agenda. Good afternoon, Venkatesh. So let's start with something interesting. My dear friends, when we talk about your intellectual property is the oil of the 21st century. Look at the richest men 100 years ago. They all made their money extracting from the natural resources or moving them around. All today's richest men have their money out of intellectual property, and that's the truth. So let's believe this truth and let's see what it is about. So the concept of IPR was discussed in 1845. Then again the issuing of protecting IPR was first discussed in Paris Convention in 1883 and Berne Convention in 1883. Both the treaty are administered by WIPO. When I say WIPO, WIPO is World Intellectual Property Organization. That means the concept is very old. So IPR is anything which originates from our mind, or we can say the creative work of human intellect or human brain, such as songs which we listen on laptop or car, or floral design on bed sheet, etc. and so on. These are all can be categorized into IPR. Now we call it as a property because other property like house, land, gold, etc. we can sell it, we can make money from it, we can trade, we can take loan from it, right? So similarly, with the help of IPR also, you can sell it, you can make money from it, you can trade on it, you can take loan also on your IPR. So that's the beauty of IPR. The property here is the knowledge expressed in the document by the owner, or you can say the inventor of the property. We do not get any right, let's be very clear, we do not get any right for idea and imagination. The information reflected in those information is real subject matter of protection. Like, I imagined a flying car, that thing cannot be protected, that idea cannot be protected, but my dear friends, but if I actually convert it into a physical subject, then it is an invention and that can be protected. IPR is confined to a particular territory. Like, in other words, we can understand these laws are applicable only to that particular territory where they are granted. For a much easier example, if any invention is granted, for example, is granted or it is a granted property in India, then only laws related to India is applicable. Those laws will not be applicable to United Nations or any other European countries except India. So before going into further details, I would like to explain you about the term of protection. When I say the term of protection, it is a number of years for which the protection is given to the property holder, or you can say inventor, or you can say owner. After the completion of the term, the invention falls into the public domain. For example, if I do any of the IPR, there are various types of IPR will be looking at it. So if I'm having the term of protection for 10 years, so after 10 years, that intellect, that property will become public. So anyone can use it. So that is the meaning of this. That is, anyone can use it after that without the consent of the owner, or we can say owner will not be able to file any infringement suit after a particular time. One more thing important, every year we celebrate World Intellect Property Day, that is on 26th of April. So let's further see how the IPRs basically categorized. So they are categorized into two different broader segment. One is your registered / non-registered category. Your second is industrial / academics. Not all the forms of IPRs requires registration. I said requires registration. In case of copyright and trade secret, registration is not necessary. For example, you might be having an institute website, right? So you develop your website and at the bottom you write the content is copyrighted for this section of department or for this section of institute, right? You never register to your Government of India. So that is the example of copyright over here. That an example of unregistered category of copyright. You can also register copyright, but trade secret you cannot. They are protected without any procedure and formality. But for the other type of IPR, we need to follow the procedure, formalities like filling up a form, paying the prescribed fees, and so on. In case we feel like better protection, if we need a better protection from the infringement, we should register our IPR. Otherwise, infringement means like someone is like taking over your intellectual property without your consent. So if someone is infringement cannot be legally combated. Now the other type is the industrial / academia. The industrial includes patent, trademark, plant breeder's right, industrial design, geographical indication, traditional knowledge, and trade secrets. When you talk about academia, it broadly includes the copyright. When we talk about copyright, my dear friend, it consists of literature, dramatic, artistic work, and one more point to be very specific in terms of copyright, does not include any industrial process. So that is your copyright. Further, before moving, let's understand these 4 terms. One is your act. When I see an act, what is the meaning of act? A bill which has passed through various legislature steps required for it and which has become a law. So this categorized is known as a primary segment. I'll repeat it once again. A bill which has passed through various legislature steps required for it and which has become a law, these are known as a primary steps. Followed by the act is known as rule. These are but obviously secondary because rule are only to refine your act, that's it. So they are in place to make the parent act work effectively. Rules cannot provides in fact the details which have not been provided for in the act. However, rules by no means can go beyond the power conferred by the act or extend the same. So rules have to be followed in the limitations of your act. It cannot extend the act in any case. The third is your amendment. Amendment is something like any changes or modification which happens in your act, rule, or in your IP or intellectual property, that is known as your amendment. Term, we have already seen, that is a validity for a period of your IPR, term of protection, your validity for any of your IPR. So let's have a look at different types of IPR. Normally we listen only 1 or 2 types of IPR, right? We listen about patent, we listen about trademark, we listen about copyright, right? But in true speaking, there are 9 types of IPR. Okay, so let's go for it. Your first is your patent. We won't be focusing much on the acts and rules here. We'll be focusing on 2 segments over here. One is the type and one is the term for which they are validated. When you talk about a patent, my dear friends, right, your patent is validated for 20 years. For example, if I apply for a patent, for example in January 2009, okay, that means a patent, if it is granted in 2010, so if I'm saying it is valid for 20 years, so it will be valid till 2030 till January. After that, anyone can use your patent without your consent because it has become public. But if anyone wants to use that patent, your idea, your intellect, your product, before that he has to take your consent. If he doesn't, that means he is infringement the rules which is being granted by Government of India. So that is the point over here. So number 1 we have finished. Let's go for number 2. That is a trademark. In trademark, the beauty is the period is for 10 years, but you can renew it for the indefinite period. After every 10 years you can keep renewing it. That's totally your choice. If you don't want to renew it, you can stop it, then someone else, if they want it, they can use it. But if you want to use it continuously till your brand exists, so you have to keep on renewing it after every 10 years. So that's the beauty of trademark. So it can be extended to any indefinite period. Let's go for the third category. The third category is your industrial design. And the term initially which is granted for the industrial design is for 10 years. And if you want for the extension, you can apply for it and you can get more 5 years of extension. That means after extension, the period would be for 15 years, but initially the grant will be for 10 years. Okay. Now let's go for the fourth category. When I go for the fourth category, that is copyright, right? So the copyright, the beauty of copyright is the term of copyright is the life of the author. If the author is like author can write, he can write a novel, he can write any scientific paper, anything, right? Any research paper, any articles, any content, right? Drama, literature, so on. So the life is the life of the author plus 60 years after his death. So that is the term for copyright. Now let's go to the next category for this slide, that is a geographical indication. The life is for 10 years, but it can be renewed for a lifetime. So my question is, my first question is to my team, whoever is attending the session. In previous slide, we have seen one more IPR, right? Which were having the same term of similar to geographical indication. Which IPR was that? Which were having the same term of geographical indication, which were having 10 years and it can be renewed till lifetime. Which IPR was that? You can answer into your chat bot. So I'm repeating my question. In previous slide, we have seen an IPR which having the similar like term of geographical indication. So which IPR was that? Having the term of 10 years which could be renewed for lifetime. So you can answer into a chat bot. I'll be waiting for your answer. So the next is your trade secrets. My dear friends, there is no act, no rules. We have already discussed before, like in trade secret there is no registration at all, right? We have seen the previous slides. So that's the reason, because there is no act, no rules, and the term is for lifetime. It is totally up to you to how much you can keep your trade as a secret. Simple as that. Okay. So now let's go for the next. Your next is your plant breeders. When you talk about plant breeders, there are two different segments over here. One is your trees and vines, that is granted for 25 years. Okay. Next is any other like trees and vines, that plants are granted for 20 years. Next is your traditional knowledge. Again, no act, no rules at all, and the term is for lifetime. Okay. So my next question is to you. In the previous slide, we have seen one of the IPR which were having term as lifetime. So my question is, in the previous slide, we have seen an IPR which were having a term as lifetime. So which IPR was that? So I'll go for the next. Next is your semiconductor integrated circuit designs and layout, and the term is for 10 years. After that, it will become public. When I say it will become public, that means anyone can use it without the consent of the owner, or you can say as a inventor. Okay. So that's an overview about the types of IPR and the terms for which the IPR is granted for. Okay. So now I'll be giving you time to mention all the 9 types of IPR with the respective term into the chatbot right away before we move forward. Mention all the 9 types of IPR along with the terms before we move forward. So I'll be giving you time right away. So best of luck for it. All the 9 types of IPR with respect to the terms you can mention into your chat room. All 9 types of IPR with the term. Best of luck. Once it is done, then we can move forward. No, patent is not for lifetime. Mr. Avinash has answered patent. Patent is granted only for 20 years. Yes, you can answer all the types of IPR along with the terms. Let's move forward. Let's finish it up, then we'll move forward for it. Yeah, trademark, it is indefinite. but it has to be renewed after every 10 years. Someone had mentioned it, but it was incomplete. So you have to mention all the different types of IPR along with that term into the chatbot. Yes, you are naming the different types. I need along with the terms as well. So write the type as well as the term. Both are needed. Yes, copyright is the life of the author plus 60 years. Yes. Industrial design, don't write 15 years, write 10 years plus extension more on 5 years you get it, right? Initially you get for 10 years, further you apply for it, again you extend it, you get for more 5 years. Done. So now let's go for the next. So after we got to know what are the types of IPR in Government of India. So let's see why to go for IPR. What is the reason? What are the objective of going to IPR? So let's understand this. Now we are going to discuss the objective behind the IPR. First is to give the recognition to the creator of the work. Every nation give recognition to the creator so as to motivate him to perform better. He is rewarded in such a way so that he can enjoy the monopoly, the economic benefits over his work. He can enjoy the economic benefits by licensing or selling his invention. Other objective is to attract the foreign investment and the transfer of technology, which we say as TOT. I'll give you a live example right away. Currently in COVID-19 situation, IIT Bombay have developed, IIT Delhi have developed a kit for COVID-19 testing, right? So they have transferred the technology to various vendors. So that is known as non-exclusive right. Non-exclusive means that they can transfer to n number of vendors. Exclusive means they can only transfer to only one vendors. So that is a clear-cut life example in this present situation. If new idea and innovation are created in nation, then it might attract the foreign investors through they may purchase a technique and the innovative technologies, or also they may offer to use of their technology in the exchange of our technology. It is also important to maintain the harmony in the people of the different kind of skills. Innovation in every field is rewarded with the protection, as the work of the innovation in any field is equally time consuming and laborious. So if the right of the farmers or artists will not be protected, then it might create a chaos between the people from different fields. So it is necessary to safeguard the interest of the owner of the work in every field. Recognition in different kind of IPR is to protect the right of artist, farmer, technical people, traders, and so on. This is not only important in maintaining the harmony, but also for recognizing for the work of the intellectual in different field. IPR can also enhance trade and investment in the country. Very true. This is obvious by now. The development of technology and innovative work would enhance the trade in particular nation. The economic status will also improve. We will also take benefits from the international trade opportunity. Grant of any right act as an inspiration or as a catalyst, you can say, for further invention will ultimately contribute to the technological development of a particular nation. So a simple golden rule, as everyone needs recognition and reward for the creation. So that's the basic objective of going for IPR. So now let's have a look at each and every IPR which we have gone through it. So we have gone through 9 different IPRs. We'll see 9 different IPRs and an overview of every IPR at this moment. So let's have a journey of IPR at this moment. Let's go for it, my dear friends. Your first one is your patent. When you talk about your patent, my dear friends, patent is a grant of some exclusive privilege right or authority. One more thing, I just wanted to add one more thing. Since there are in 9 different IPR, among 7 to 6, after every explanation of every IPR, I have kept 2 questions, right? 2 or 1 questions which you will be answering to your chatbot. So please be attentive on every IPR, okay? So among 9, only 7 or 6 or 8 might be having the questions, okay? So best of luck. Best of luck for your exam. So after every explanation of IPR, you have to give your exam into a chatbot. So let's go for it. So let's restart. Patent is a grant of some exclusive privilege, right, or authority, you can say, given by the government of the country to one or more individual for a limited period of time. I want the answer. We have already seen what is the period of time for a patent. So we have already seen what is the term for the patent. Please answer into a chatbot. So for a limited period of time in exchange of disclosing the invention. Inventor has monopoly right for the particular period of time where he can sell or import or use his invention according to his own wish. For example, in India, the patent is granted for dash years. You will be answering it. So all these years, an inventor can rule over his invention and can use it in every possible way because it is his property, it is his right, right? He can use it. By using in every possible way, I mean he can license his invention to anyone, can assign his invention to anyone. So let's take one of the famous example, IBM. IBM licensed technology to many dealers, right, and earn money from it. How? Basically, IBM earns royalty from it. So we can take an example like a patent of a company like Apple, like Apple's new technology which is shake to charge. We can also take an example of a patented medicine like Combiflin. So this is all about your patent. So now further, based on this overview of patent, you'll be displayed two questions. Every question will be displayed for only for 15 seconds. Then the question will be stopped. So best of luck for your exam. You can answer into a chatbot. You can answer the options A, B, C, D, whichever is your option you feel it is correct. You can answer it into a chatbot. Okay. So here we go for it for your patent. So your question number 1 is, what protects the intellectual property created by the inventors? A, copyright. B, GI. C, patent. D, registered design. E is your trademark. So you can answer your option A, B, C, D into your chatbot. Best of luck. How long do patents usually last for? 10 years, 20 years, 40 years, 60 years? A, B, C, D. You can answer into your chatbot. Just answer A, B, C, D. That's it. That is sufficient for it. And after 4 seconds, your answer will be displayed to you. Then we can move ahead for the next. So the correct answers for both the questions are, first one is C, that is patent. When we talk about inventors is applicable for the patent, not for any other IPR. Patent life is for 20 years, that is option number B. So now let's start with the trademark. Trademark enables the consumer to identify the product by certain symbols. So you have in one of the example of symbol over here. This will help them to distinguish the product and the service from one trader to the another trader. The trademark helps to get the goodwill in the market. As you all know, a famous McDonald's in which you see a joker often sitting like placed outside the store, right, and a yellow color which way they write the McDonald's. You can easily understand that this is McDonald's store and we'll get a good quality food over here. This is how a trademark protects the goodwill and the quality of the owner and the product. It also helps in identifying the trademark. Trademark can directly appear on the product. For example, like you can talk about slice bottle, Mazda, Coca-Cola bottle, ringtone of Nokia, ringtone of MI recently which is becoming very famous, punchline of Lay's like Pal Banai Magical. And there are some trademark which become very generic like Xerox. Xerox was registered as a trademark as electrophotography copying machine and apparatus for fusing powder images in 1952. Used widely in this kind of copying technology, thus reach a point in 1970 that the trademark almost become generic, the descriptive mark, because many people refer to photocopy or photostat as Xerox. Trademark has 45 different classes. If you want to register a trademark, a brand name in Government of India, there are 45 different classes where you can register. This 45 broadly divided into two different class 1 to 35. That category is granted as goods category. If anyone is dealing with goods, they have to trademark their product into this class. And class 36 to 45 is been granted for your service category. If anyone want to have a trademark for a service industry, they have to go for this category. The term of trademark, which we have already discussed, that is for 10 years, and it can be renewed after every 10 years for an indefinite period. So that is an overview about for a trademark. So now let's go for your test series. Okay, so depending on the overview of a trademark, let's go for it. This is the basic standard, one of the famous trademarks. Just an example to display for you, for your understanding. So let's go for it. So you'll be having only one question, and that question will be displayed for 15 seconds, and you have to answer it in that period in 15 seconds. Best of luck for your time. Best of luck, team. Here we go. It's 3, 2, 1. Best of luck, my dear friends. And the question is, what is the duration for of trademark registration as defined by the Trademark Act in 1999? 2 years, 5 years, 10 years, or D, depends on the commercial value of the infringement. So you can answer your options A, B, C, D, and the correct answer for this is yes, you are right. It is C, that is for 10 years. It doesn't depend on the commercial value. The criteria is fixed. Whatever the commercial value is, the duration is for 10 years, and then we can keep on renewing it. So your next category over here is, which we'll be discussing, is your industrial design. So let's go for it, my dear friends. So industrial design protects the distinctive appearance of product. Very important. It protects the distinctive appearance of product. These right is only concerned with the look of an article, guys. This is very, very important point. These rights is only concerned with the look of an article, not as how they function. So industrial design only depends on the look, not as how they function. You can take many real life example like shape of a sports bike you like, a floral design of bed sheet, handicraft, manufactured products, design of gold, design of diamond jewelries, and so on. Now, an industrial design can be of 3D form, 3-dimensional. A 3-dimensional form, it can be like a shape of a car. It can also be a 2D. A 2-dimensional can be like ornamentation color, a color combination of a chocolate wrapper, and so on. It can be a combination of both the features, a 3-dimensional features as well as a 2-dimensional features. Suppose a famous Volkswagen car has an elegant 3D design shape as well as it has a very unique color. So it can be patented into an industrial design in both the categories, for 3-dimensional as well as for 2-dimensional. So that's the beauty of it. So industrial design adds commercial value for the product. How? Let's see. Design makes product good looking and attractive. Yes. Good looking finished products must be appealing for the consumers. Yes, it has to be, so that he prefers buying that over boring design. Very true. We never buy a cell phone that has all the features but it is not good looking. That's the reason we never buy it, right? Industrial design are very important, like adding looks factor for the product. So it is very important to enhance the design of your product. So, and also the term of the industrial design is for 10 years. It can be further extended or on request for more 5 years on application, in fact. So that is all about your industrial design. So it includes all the configuration, the pattern, the design, everything is included in the industrial design, but not the process. Okay, so that is all about your industrial design, my dear friends. Now let's see few questions on industrial design. Let's have a look, my dear friends. So you'll be having 2 questions. Each question will be displayed for 15 seconds. You can answer into a chat room with your only option. Don't answer the complete answer, just the options A, B, C, D, whichever you feel like. So here we go for it. Best of luck, my dear friends. Let's go. What is encompassed in design as per the intellectual property law? Feature of shape, configuration, pattern, D, all of this. Next, what is the duration of a design registered under the Design Act 2000? 2 years, 5 years, 10 years, depend on the commercial value of the infringement. And the correct answers are: industrial design has the feature as well as the configuration as well as the pattern. It doesn't have the process, and the duration is for 10 years. Further, if it can be extended for more 5 years on the application. Thank you so much. Few were wrong, please correct. Majority of them were right. Very good. Appreciate your efforts. Thank you. Appreciate your efforts. Amazing team. Wow. Next is your copyright. So let's go for it. I listen to FM every day. Like, I love songs, so I hear songs of Arijit Singh, Sonu Nigam, Rahul Vedya, A.R. Rahman, and so on, right? All the singers have copyright for a piece of work done by them. Then broadcasting rights are also given to these FM broadcasting organizations. So copyright is concerned with the protect of original literature, artistic work, and so on. Copyright subsent in original dramatic, musical, cinematography, film, and so on. Copyright Act was formed in 1957, but my dear friends, it came into effect. Copyright form came into effect in January 1958. We can take example of copyright that is the right of a performer. We can say famous actor like Salman Khan has a right to control his performance given by him in any stage show. Then right of broadcasting organization, like we can talk about here, we can take example like FM channels like FM Gold, Red FM, and so on. They have a right for broadcasting and rebroadcasting of their program. We can take other examples like A.R. Rahman songs, M.F. Hussain painting, and vice versa, etc. Copyright is often called as a bundle of rights. Now you'll be questioning why it is called bundle of rights. Now let's understand why it is called bundle of rights. The name is given since its main work is to protect the authorized use, but also add several other rights to the list of the owner. Another, like get the right of the reproduction in various forms such as printed publication or sound recording form. Public performance can be done, such as the novel can be converted into a theatre play. You might be remembering a movie known as Two States, right? It was launched and it was based on Chetan Bhagat's novel. So Dharma Production has to take a copyright listing permission from him, then only it could resolve, right? They could take the right of that particular novel. So that is one of the best example over here. Then the recording of the work can be made in the form of compact disc, cassettes, videotapes. Broadcasting can be done by radio, cable, satellite. And then its translation into another language or its adaptation such as conversion of novel into a screenplay can be done. All these rights can be enjoyed by the owner of the work, hence the name bundle of rights is justified for this kind of IPR, my dear friends. So now, after having the overview of copyright, now let's have a look a few questions on copyright. So you will be having 2 questions on copyright. Every question will be displayed for 15 seconds, then the right answer will be displayed in front of you, but please make sure you answer into that 15 seconds. So here we go for it. It's 3, 2, 1. Best of luck. Is unpublished book can be registered under Copyright Act in India? Yes, no, yes in some cases. So what's your answer? You can answer it in the chat room. The Copyright Act 1957 came into effect from January 58, April 58, June 58, August 58. Correct answers are yes, because copyright is therefore only for the unpublished work, right? Published work cannot be copyrighted, and it came into effect in January 1958. So now next will be your GI. When I say GI is your geographical indication, very interesting topic. GI basically is a tag, or you can say a notice stating that a given product originates in a given geographical area, or a product is manufactured in a given geographical area. My dear friends, colleagues, you might be knowing it, every area or every district or particular city or particular your native place might be famous for a particular product. It can be a handicraft product, it can be a industrial product, it can be a fruit, it can be anything, right? So my challenge is like, you have to mention your native place is famous for what, or your city is famous for what. So mention it into your chatbot. So I want to see. So let's see at the end we can have some similarities or not. So mention your city, your native place is famous for what. It can be anything. It can be a product, it can be a manufactured product, it can be a fruit, it can be sweet, and so on. It can be a material, it can be clothes, and number of things, right? So let's mention it into your chat room, so that we can further discuss your GI in more effective way. Now, tags is given to the product for quality, characteristics, and reputation. So these are the three important things: quality, its characteristics, and reputation. These features can be found if the same product is manufactured or grown at some other place. These rights is applicable for manufactured or originated goods. These characteristics or quality may be due to major factor like natural factors, or you can say at method of manufacturing. So now the natural factor could be like soil, regional climate, temperature, moisture, and so on. For example, like Nagpur oranges, for like method of manufacturing can include specialization in the product or preparation methods like Tirupati Laddu. The geographical location promotes goods or producers of a particular area, so that the consumer will be sure about the quality of the originated or the manufactured product. And if like what is the advantage, like similarly, like if anyone wants to like export it, right? So the export quality would be very good for that particular product or fruit or something which is very famous for that particular area because of some geographical indication. So that product will get a very high value if it is originating from that particular area. Like someone said ki Kolhapuri chappal and so on, like halwa, mango, aleem, and so on, right? Lemons of Bijapur. So these are the few peculiar things which, if they are famous for that particular area, so they will definitely get a higher economic value compared to other value, because like people will be aware, yes, this quality is good. So that is the advantage of having geographical indication. So it helps the farmers and agriculturalists or producers to get a very good value. Like we talk about mangoes, Alfonso mangoes, right? So it has a good value compared to other mangoes. They are extremely expensive compared to other mangoes, right? For them, if we want to purchase mangoes, we have to purchase in dozen, and other mangoes like we purchase in kilo, right? 1 kilo, 2 kilo, and so on. So the price and the economy is there is lots of difference in that. And one more very important point when you talk about GI, if there would be any infringement, like someone is selling like Nagpur oranges are very famous in Maharashtra, okay? If someone is like selling oranges from Nagpur, like example, if someone is producing orange somewhere else, not in Nagpur, but he's selling as this orange belongs to Nagpur, that means he's doing something illegal, right? So that means he's infringing their rights. So if there would be any infringement, in this kind of infringement, then in that case there are two kind of categories who will take action. One is the registered proprietor, and second is the authorized user. So these are the two people who will take action against those people. Second, further, to understand more, Geographic indication. So this is the when we talk about tags. So this is what is about. Currently, this is the tag for 2017. So the highest ranking is Karnataka at this moment in 2017. Very old. I couldn't get the updated sheet over here. So Karnataka and so on. Karnataka, Uttar Pradesh, Odisha. This was the number of tags. So few of the products like we can talk about Darjeeling tea, Bikaner bhujia, Agra pitha, Nagpur orange, Kashmiri Pashmiana shawl, Lucknowi chicken craft, Kanchipuram silk sari, and many other. So these are the basic very famous example about when you talk about geographical indication. So that's the beauty of geographical indication. So now further, after understanding GI, let's go for MCQ on GI. Best of luck, my dear friends. So you'll be having two questions which will be displayed for 15 seconds each. You have to answer it into your chat room. So you just have to answer your options A, B, C. That's it. That's sufficient for it. So here we go for it. It's 3, 2, 1. Which of the following are included in the geographical indication of goods? Handicraft, foodstuff, manufactured stuff, D, all of the above. Just mention A, B, C, D, whichever you feel it is the right answer. Who can initiate an action for the infringement of a geographical indication? The government, the registered proprietor, authorized user, an individual having interest. Only 2 and 3. F, all of the above. The correct answers are, it includes handicraft, it includes foodstuff, it includes manufactured products, all of the above. And two people, very important people, the registered proprietor and the authorized user, they have the authority that they will be complaining if there is any infringement in case of GI tags, if someone is misusing the GI tags. So now your next is your trade secrets. Basically, my dear friends, this is an information. The name itself says that you do not want the competitor to know about. Simple. The law generally protects not a secret formula and design, but even the simple facts like the features that might be introduced in the next Samsung iPhone IMI, or which country a business intend to go into next. Then we can go into, like, we can talk about the famous trade secrets of KFC, McDonald's, Coca-Cola, Google, because the information that is used in this operation of a business, and once the trade secret is revealed, the value of the trade secret also goes away. Simple. Like you taste a KFC or McDonald's or Domino's or any other, if you taste in Maharashtra, you taste in Karnataka, you taste in Tamil Nadu, you taste in Rajasthan, you taste in any other place, right? The taste would be same. So that is the secret about it. You taste in Dubai, you taste in any other country, the taste would be almost same. So that is the trade secret for their recipe. The value here is the economic advantage over the others. So your competitors will copy the secret recipe or the formula or the trick to make the business successful. We can say that the trade secret can be business related information like the financial corporation, customer list, manual, and so on. And we can also talk about technical related stuff like drawing models, prototype, manual, designs, which comes under trade secrets. So one of the most important thing, as we have already seen in the previous case, right? I wanted some answer over it. Were the trade secrets having any acts and rules? Yes or no? In the previous slides we have seen about the acts and rules. Were the trade secrets were having any acts and rules? Yes or no? First question. Second question, what was the term for a trade secret? 10 years, 20 years, or what? What was the term for the trade secret? Before moving further, I need the answer for these two questions. Because my dear friends, when we talk about trade secrets, there is no term known as a confidential property, right? Because like confidential property, because when you talk about property, it has to be registered, right? So there is no registration at all. That's the reason there is no act, no rule in trade secrets. So there is no term known as there is a confidential property. So it is not a property at all. It is not registered. So this point has to be taken care of it. So now let's go for the further example. One of the famous example is Coca-Cola. The secret has been kept in the vault of bank in Atlanta. So it is one of the very old brand. So the recipe, the syrup, it has been kept as a trade secret, because if it is revealed, then he will lose an economic benefit over the market. Simple as that. So that is the value advantage of economic benefits when you talk about a trade secret. So now let's go for a question. You will be having only one question and it will be displayed for only 15 seconds. Then you will be showing the right answer. Here we go. 3, 2, 1. Best of luck. What is not valid for the legal nature of confidential information? What is not valid? A, B, C, D. The question is little tricked. Not valid. And the correct answer is confidential information is property. It is not valid, because when we say about property, it has to be registered. Trade secret is not at all registered. It is kept as a confidential information. So please take care of it. So your next is over here is that is known as TK, that is traditional knowledge. Very generic. These knowledge is gained and used by the people over generations. These types of IPR is given to knowledge that is common in particular community, like the knowledge of turmeric, or you can say the use of turmeric for wounds and etc. Then this knowledge is carried from one generation to another. Knowledge is difficult to preserve in the form of a proof. We all know India has a rich traditional knowledge that is passed verbally from our ancestors to us, from one another. That Indian government has taken an initiative of developing traditional knowledge digital library, that is known as TKDL. So you can, whenever you have time, you can just visit the website as well, TKDL. This project was initiated in 2001. India fought revocation of Basmati rice patent granted by the USPTO. TKDL is a collaborative project of Council of Scientific and Industrial Research, that is CSIR. Then the Ministry of Science, Technology and the Ministry of Health, Family Welfare have been helping this project in implementing at CSIR. Now few example of traditional knowledge like use of tulsi, neem tree and turmeric in India. We can also talk about Ayurvedic medicines, the use of aloe vera in removing pimples. This is all mentioned in TKDL website, that is Traditional Knowledge Digital Library. TKDL is mainly of a partial nature, like partially divided into mainly for the following categorized: agriculture, fisheries, health, horticulture and forestry, and many other, but these are the major factors in which the TKDL is divided into: agriculture, fisheries, health, horticulture and forestry. So that is all about your traditional knowledge digital library found by CSIR in 2001 and maintained by ministries. So now let's go for the next type of IPR, that is your plant breeders' right. And Indian breeders developed a large number of new varieties that are freely available to others for exploitation. Simple. But plant breeders' right are also known as the Protection of Plant Varieties and Farmers' Right Act 2001, also known as the Protection of Plant Varieties and Farmers' Right Act 2001, which protects the interest of breeders and farmers. These rights safeguard the interest of farmers of India. It is an incentive for farmers and breeders for the development of improved plant varieties of agriculture, horticulture and forestry. Exporting it, you can exporting it, importing it, then we can offer it for sale, selling it, or any sort of marketing we can do, stocking it for any of the above purposes. Example like commercial strawberries, vine apple and so on. So now I need what is the term for plant breeders. Is there a single term, or in case of plant breeders the term is divided into two categories, single term or two terms. If it is two, so mention both the terms with their years it is valid for. Plant breeders, right, is valid for how many years? If it is there is only one category, or there is two category. If there is two category, mention both the categories name along with the term for the same. Okay, I'll be waiting for your answers for plant breeders, right. Let's go for it, my dear friends. Best of luck. So now we'll be going for the next question on plant breeders, right. Yes, many of them are right. Very good, extremely proud of you, my colleagues. Perfect, 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 perfect. Very nice. Let's go for the question series. Thank you so much. Appreciate your efforts. Appreciate efforts in afternoon. Appreciate efforts. Let's go for it. It's 3, 2, 1. Best of luck, my dear friends. There will be two questions, 15 seconds. After years of research, a scientist grows an entirely new variety of plant which does not exist earlier. The flower of the new plant have a great medicinal value. Can this new variety of the plant be patented in India? In the previous example of a new variety of plant having flowers with medicinal value, the protection can be availed for the following new plant under which act? Which act? A, B, C, D, E. The correct answers are yes. Since it wasn't registered, yes, it can be. And the act is the Protection of Plant Varieties and Farmers Act 2001. And the last type which we have for IPR is your semiconductor circuit layout designs. So let's go for it, my dear friend colleagues. The last type of IPR, that is semiconductor integrated circuit and layout designs. The creation of a circuit and its layout design has been given a separate category of protection under IPR. As smaller the size of an integrated circuit, the lesser the material needed for its construction and smaller the space needed to accommodate it. These conditions requires lots of efforts by the technical people, and as protection of these efforts have become important. It provides protection for semiconductor integrated circuit and layout of these circuits, which plays a significant role in advancement of technologies, especially for electronics and information technologies. Integrated circuits are used in all the data processing equipment like mobile phone, laptops, watches, radios, washing machine and so on. Semiconductor integrated circuits are often called as like microchip, or it can also be called as chip. It can function as timer, counter, microprocessor and so on. It can be a digital or analog. Integrated circuit layout design refers to a 3D characteristics of element and interconnection of integrated circuits. For example, a layout for transistor and any other circuit element. Especially anyone working in physics, anyone working in electronics, anyone working in electronics and telecommunication, electrical, they can surely go for this kind of categories, except of PT. That is one of the options, you have it, but definitely even this kind of option you get it. So let's recap few of the important points of IPR before ending the sessions and before moving forward the further surprise what we have for today. So I'll pick up few of the IPR and few of the important points which will really give you a brief impact and brief overview of the session. So let's talk about copyright. It protects the intellectual property created by the artist. We have seen previously in question, if it is created by the inventors, it is for patent, and if it is created by the artist, it is for copyright. Like you can copyright a story also, simple. Right way of using a content from a CD is to purchase a CD, copy it to a laptop, and for your own private use. One more example, a singer wishes to assign the right to reproduce a video. It will only happen when, that means she has the copyright of that concert. It is applicable to songs, lyrics, musical compositions, sculpture, paintings, dramatics, literature works, and so on. So that was a small recap for copyright. Let's talk about industrial design. Industrial design can also be known as a registered design registered design that protect the IP created by the designers. Created by the inventors is patent, created by the artist is copyright, and created by the designers is industrial design. Design does not include any like mode or principle of construction, only the look. Design which is distinctive, and if company wishes to ensure that they have the sole right, and it should have an industrial design which has to be registered. Okay, so next talk about geographical indication. Like champagne is one of the GI tag from France. Like France is very famous for champagne. Sign used for GI tag may be a name of a geographical place, or a symbol, or a map. Second, when you talk about a word known as a producer in GI, geographical indication, a producer is a person who produces or processes or packages agricultural goods, natural goods in making or manufacturing goods, or handicraft or industrial goods. So this is categorized under producer. And the term year for GI is for 10 years, and it can be renewed for indefinite period. Okay. Next is one of the last important point for GI is GI. What it does, it creates a link. Okay, very important point, my dear friends. It creates a link between some characteristics of the goods and a particular region. It creates a link between some characteristics of the good and particular region where it is produced. So now let's talk about trademark. When you talk about your trademark, you already know what is the right and so on, right? Trademark is registered, it has to be registered, like it is a brand name which has to be registered. If a company wishes that no one else should use their logo, they should register the trademark. It identifies a product design. It can be renewed after every 10 years, that is the lifespan of trademark. It protects, very very important point, it protects words, symbols, or the device that differentiate goods or services, right? So my question is to you, my dear friends. Now we have seen in trademark there were how many classes they were there in trademark? 1 to how many? That is a question to you. Okay, 1 to how many? 1 to dash. You will be filling up the answer. Okay, along with filling up the answer, my dear friends, I need that classes were divided into 2 categories. I'll give you a hint. One category was goods and one category was services. Okay, so I need the answer key how the goods category were divided, okay, and how the service category were divided. I need the number. Okay, so just waiting for your answer for trademark. How many classes were there? And there were 2 classes. I already gave you the hint. One category was goods and one category was services. Okay, so tell me how it was divided. Goods is from how many? The range of goods and the range of service as well of the classes. Amazing, amazing answers. Thank you. Yes, the answer is right. Now tell me for goods, it is, yes, someone also is, Ashwini already answered. Very good, Ashwini. Harshita also answered it. Very nice. Yes, Amisha. Perfect, perfect, perfect. Very nice. Yes, yes, very nice. Amazing, amazing, amazing. And the important point for trademark is the technical shape of the goods cannot be registered under trademark. Not the shape. Shape is for industrial design. So let's talk about your patent. Few points. A technology that improves its main product cannot be stopped by others from copying their invention only if it is patented. One more life example. A new way to process a milk, for example, so that there is no fat in any cheese made from it, and this process can also be patented. Next, we spoke about WIPO. WIPO is World Intellectual Property Organization. Okay, and it is celebrated on 26th April every year. Okay, and last thing about trade secret, there is no rules, no act for trade secret, but thing is that you have to take care of it. It should be of right type. It must not have been previously made public for trade secrets. And last before ending is IPR. It protects the use of information and ideas. It protects the use of information and ideas that are of commercial value. It has to have a commercial value. So that is the benefit of IPR. Okay. So that is all about this thing. That was the first part of the session. Since because of time constraint, since I didn't got 2 hours for it. So the second slot was all about patent. The second session, which I normally teach, is all about patent in depth, how to file a patent, what is the process of a patent, and so on. Because before that, you have to really understand what are the different types of IPR before understanding each of the different IPRs, right? So whenever we have time, whenever we can have time with the SECAB Institute, then we can surely have a session for patent as well, in detailed process for patent. So this were the different types of patent which you saw today. That is patent, trademark, industrial design, trade secret, geographical indication, copyright, and your plant breeders, traditional knowledge, and your semiconductor integrated circuit layout designs. So this were the 9 IPRs which you saw it today. So that's what all for today's session. So I know I cannot answer each and every question of your doubts, right? So there is 121 different FAQ questions which has been made for all the types of IPR, right? From patent till plant breeders, everything. Okay, the link, where this FAQ question is, the link has already been shared with the coordinator of this SECAB Institute. So they'll be sharing the link into your WhatsApp group. So don't worry at all. Okay. So complete. Whoever wants to learn more about IPR, please go through this 121 different kind of questions. It will clear all your doubts about your IPR, of each and every IPR. So don't worry at all. Okay. I understand that 1 hour is not sufficient, but I have really managed to curtail it down to the important points in 1 hour. Okay. And that is your surprise for today. You'll be having a test series, my dear friends. You'll be having 39 questions. Trust me, this test series won't be as simple as the webinar test series which you are currently taking in the other institution, which is much more easier. There are T categories. Person who is getting less than 40%, he'll be considered fail. Please make sure this test is not compulsory to everyone. Even if you don't attend this test, you will be getting your participant certificate from the institution. Okay, so this test series is completely taken by me. Okay, this certificate will be completely given by me. Participation won't be given by me, it will be completely given by the institution. Okay, no doubt this certification will be approved by the institution as well. Anyone scoring in this test series between 40 to 59%, he'll be getting a certificate of appreciation. Anyone scoring between 60% to 79%, e-certificate of merit. Anyone scoring 80% and above, he'll be getting e-certificate of excellence. Please mention that there won't be more than 1 attempt. Anyone who will be taking more than 1 attempt, he'll be straight away, that category straight away will be discarded by the software, because this test series will be completely taken by the software. The software link is been shared with the coordinators, so don't worry about it. about the link and everything, it will be shared by the coordinator, because the team is fantastic with SECAB. They are working extremely well. In the morning session, the completely fault was mine because of my technical glitch. It was not at all the fault of SECAB Institute. They are working really hard for this. They have been working really hard for this webinar. Okay, please make sure the time limit will be given for 30 minutes. This link will be deactivated by 6 p.m. Anyone taking this test after 6 p.m., their marks won't be considered, and the link will be deactivated. They cannot take exam after 6 p.m. Okay, so they can give the exam before 6 p.m. anytime of their own choice. Okay, so more than one attempt is not at all allowed. Please make sure about this. Okay, so this is the link where you can give your examination, my dear colleagues. That is testmoz.com/q/SECAB, and there is a passcode, there is a code which is SECAB. Please make sure it is a case sensitive. It has to be in caps lock, capital SECAB. Don't type in small. Okay, it won't work. It will show invalid, my dear friends. Okay, so that is the above link. Even the link has been shared with the coordinators, so don't worry about the link. Everything, link, FAQs, everything is being shared with the coordinators, so don't worry about it. Relax. So this is something which you will see when you log into that link. You have to go into the student login, enter your full name which you want onto your certificate. If there is any mistake in the name, your certificate won't be reprinted or remade, right? So please make sure you have to send a correct name. So you have to write your complete name and your complete email ID, okay, and your passcode. All the certification will be sent to the team of SECAB in 48 to 72 hours. It will take minimum 48 to 72 hours, whoever will be clearing it. So there will be two things will be given. One will be the list in every category who have cleared in appreciation category, who have cleared in merit category, who have cleared in excellence category. Along with the list, then the certificate will also be mailed. It will be mailed via link. Okay, so you can go to the link and can download your own certificate. So don't worry about it at all. It will take at least 48 to 72 hours. Any query regarding this, you can mail it to me. Any query with the certificate, please make sure you have to put your right name. Okay, my dear colleagues, for it. And this is a disclaimer, whatever image which have been used, it is not at all for your business oriented. It was totally for education purpose. So anyone who wants to connect to me regarding your patent, regarding your IPR, you can connect to me. That's my profile, that's my website, www.awab.com. Currently I have filed 16 patent, including design and patent, and I've been advisory committee member for various institutions in the IPR cell. So any support you need from my end, I'll be really happy for it. I'll be really happy if you can communicate me via WhatsApp or mailer. Then if things needed, then we can talk on via caller. Previously it is preferred if you can communicate via WhatsApp and mailer. Okay, if you can mail it to me, that's my social media profile. You can have a connect. We can further discuss on it. Thank you so much for your time. Appreciate your efforts. Amazing crowd. You were very active. I could really feel that with your passcode is already mentioned, so don't worry about it. Okay, everything will be given to you by the coordinators. I really thanks the SECAB Business School team, the principal, the heads, the team, Professor Arif, who was constantly in touch with me, the director of SECAB, Mr. Salahuddin Punekar sir, the chairman Punekar Saab. Thank you so much for giving an opportunity to interact with amazing crowd and given a webinar to a fantastic institute like SECAB. Thank you so much. I'll be signing off for my webinar right away. Thank you so much.